A lot of times we hear from our past clients for post-judgment issues. I think at first it's a really big adjustment. It's not always just perfect after the divorce.
Welcome to Tailored Wealth. I'm your host, Taylor Mavrakos. In my 10 years as a financial advisor, I've noticed that when it comes to finances, women are often considered an afterthought. My intention with this show is to create a space tailored to women as we navigate choices throughout our lives. And here today, I have a divorce lawyer, Nicole Gehringer from Harris Hunt & Durr. Nicole, thank you so much for coming on the show.
Thanks for having me, Taylor.
So tell us a little bit about your life as a divorce lawyer.
All right. I've been practicing about 10 years now. So after law school, I started as a judicial staff attorney in the 13th Circuit, which is Hillsborough County. Did a little bit with a criminal judge, but then I ultimately ended up in unified family court. So helping the judges with researching certain issues, drafting proposed orders. And then I transitioned to private practice almost 8 years ago at this point. So handling divorce cases, paternity, pretty much most things family law related.
What do you love most about your job?
Probably helping people get out of some really bad situations. And then years later, getting Christmas cards or thank you notes or first day of school pictures, just really seeing people excel in their post-divorce life. It's refreshing to know that I played some small part in getting them out of bad situations. Now, let's be real, not everybody wants the divorce, but sometimes it's really necessary. And so helping those people get out of bad situations and then seeing how well they do after the fact is the most rewarding part.
I totally relate to that because, as you know, I'm a certified divorce financial analyst. So I just deal with the financial piece. And a lot of my job, I feel kind of spoiled because I get to help so much with the post-divorce, kind of the light at the end of the tunnel. So I want to walk through, I have so many questions for you, but I kind of want to walk through the process for anybody that's watching, depending on what part they're in. I kind of want to take us from start to finish.
Okay.
Let's talk the person that is in a marriage, they're contemplating separation, they're contemplating divorce. What advice do you have for that person?
First and foremost, consult with a lawyer. I mean, the biggest thing going through a divorce is making informed decisions in my mind. And that doesn't mean relying on advice from your neighbor or your friend or your family.
Or Google.
Right, or Google or ChatGPT. Sometimes it can be valid information, but every case is so different. One person's divorce looks so different from another person. So I think people walk into divorces thinking that the outcome might look a certain way, but it's really very different. So I think making informed decisions starts with a consult. Now, lawyers have different types of consults. Some lawyers offer free 15-minute calls. You can only get so much information in a 10 or a 15-minute conversation. So it might be, and in my opinion, it is worth sometimes paying for a paid consult where you have a longer period of time with a lawyer to get more in depth about the facts of your situation and what you might get out of a divorce. So making informed decisions starts really early on. I think meeting with more than one lawyer is sometimes a good suggestion. Making sure that that lawyer is the right fit for you, making sure that the lawyer's not over-promising or guaranteeing results, because none of us, no matter how much experience we have, can predict what a judge would do if your case gets to that point.
And I love that you said no ChatGPT either, because something that I've seen with clients lately is they're asking ChatGPT all these different questions. And the reality is that people don't realize divorces are all customized, right? They think like, well, you go and then you get this judgment and you're done. And it's a lot more complex than that, right?
It really is. I mean, it truly depends on income levels, monthly expenses, assets, valuation of certain assets. I mean, some cases are more simplistic and some are more complex, but ChatGPT has no way of knowing the facts of your situation. So while it can probably answer maybe some more simplistic questions, it's not tailored to a specific divorce or a specific family at all. So beware, basically.
Can you talk a little bit about, I interact with clients who are in that contemplation period and they have a lot of anxiety about who's going to file and if they need to hurry up and start talking to a bunch of different attorneys. Can you shed some light on that aspect of it?
Who files first is always doesn't matter who races to file first. Doesn't really matter who's the petitioner and who's the respondent in my mind, but the timing of filing could be important in certain circumstances. So when someone does file a petition for divorce, it draws a line in the sand for the creation of marital and non-marital assets, generation of marital versus non-marital income. So there are some legal implications of when somebody does file, but it doesn't actually matter if you're the petitioner or the respondent. So every case is a little bit different.
What about this idea of like conflicting out that people worry about?
Yeah, so lawyers have tons of ethical rules that we have to comply with. So conflicts are a big thing. Before we can talk about specific circumstances with a client, we do have to run a conflict check to make sure that we haven't already had substantive discussions with their spouse or soon to be ex-spouse. So some people do strategically try to meet with a lot of lawyers to conflict out whomever they think that they want to. Do I suggest that? Probably not. But do people do it? Absolutely.
And I've heard this about therapists before, that the success of your interaction with a therapist is very much the relationship you have with your therapist. How much of picking the right divorce lawyer is really just making sure you have that connection with them?
I think a large part, well, one, obviously you should pick an experienced lawyer who practices in the area of law that you need. So all our firm does is family law. There's 9 of us. We practice 100% family law. We don't dabble in other areas of law, but there are lots of lawyers who practice multiple areas of law. So you should figure out what you want and what you need. And who's capable of helping you. Making sure that your divorce lawyer is the right fit, I think, is a huge part of it. Because if you're not comfortable having conversations, they're not going to be able to zealously advocate for you in the process. Because if you're not comfortable sharing some of your deepest, darkest secrets that your ex-spouse is going to raise, your attorney can't represent you to the best of their ability. So finding someone that you can communicate really well with, I think, is a big part of choosing the right attorney for you.
I totally agree. And I think to circle back to that competency piece and really looking at lawyers that specialize in family law, I had a friend of mine who works in civil litigation, and she told me there's family law and then there's the rest of the law. And she was like, and a lot of times you either love family law or you dabble, if you will, in a lot of other areas. Have you found that to be true?
Yeah, a lot of people and a lot of lawyer friends that I have would never touch family law. I mean, they have no interest in it. We do have our own set of procedural rules. We obviously have our own chapter in the statute. So our rules are not the same as regular civil rules of procedure or criminal rules of procedure. So family law does have its own area of the law that obviously you should be familiar with if you're representing family law clients.
And isn't a little bit of it, when we talk about that competency piece too, knowing the judges in your area, because it can be a little judge dependent based on what goes on?
Yeah, I mean, you can never guarantee getting the same ruling from the same judge or from different judges in the same circuit. So if you had 5 courtrooms, let's say in Hillsborough County or Pinellas County, there's no guarantee that you would get the same outcome if you took the same facts to 5 different judges. They're people. Every case is fact specific. Judges have a lot of discretion in a lot of the family law arenas. So it's who you get. And it's a random assignment. So there's no picking and choosing who your judge is. You file your case and they're randomly assigned by the clerk's office. And you then a few days later find out who you're assigned to.
Oh boy.
Yeah.
So yeah, just very important. Like we talked about, you don't even have a straight answer, consistent answer amongst judges. So when people think, it's just one size fits all for divorce, that's not even the case in terms of what judge you get assigned to, it sounds like.
Absolutely. And it depends how new or how experienced your judge is. If a judge has been on the family law bench for 10 or 15 years and you've had a handful of trials in front of this judge on a similar issue, there's some level of predictability in a future ruling. But you could get a judge that it's their first day on the bench. Or you could get a judge that rotates into your division in the middle of your divorce case. So a lot of it is out of your hands and out of your control, but us family law attorneys, we are involved in a lot of organizations with the judges. And so we try to interact with the family law bench and get some insight as to their thought processes, how they apply the law to certain facts and certain cases. And that really helps us when we're counseling our clients.
So when you said that judges are randomly assigned, can you say, I don't like my judge, I want a different one?
No.
Can't.
There are legal bases to try to recuse a judge, but just I don't like him or her is not a sufficient basis. Work. No, otherwise, okay. I mean, it's called forum shopping, and that's what the law doesn't want. They don't want you to be able to pick and choose your judge.
Gotcha. So you've picked your attorney, you've picked your judge, or you have not picked your judge. It's randomly assigned. Yep. Your judge has been picked for you, and you're in it, and you're in the process. I'm sure a question you get all the time is, how long is the process? What does the process look like? There are probably 14 million different ways you could answer that, but what's kind of your standard that you tell people?
Yeah, that's the $1 million question. It truly depends on your spouse, how reasonable they are, if you're going to litigate every issue, if you're going to enter into the collaborative divorce process, if you can settle your case at mediation. So it truly depends. So when one person files a petition, the next step is to serve the other spouse. You can either do so by a process server, or the other spouse or the lawyer can accept service on their client's behalf. Once that's done, that starts some time frame. So you have 45 days to exchange mandatory disclosure, which is financial disclosure of certain documents in a financial affidavit. And then generally after you exchange financial disclosures, you go to mediation. There can be a lot of steps in between there if you have a more complex case with business valuations, or you need a guardian ad litem or social investigator involved. But generally, mediation is the next step. A lot of cases settle at mediation. Sometimes there needs to be some more fact development, maybe some more discovery or depositions. And then some cases settle at a second or third mediation.
And mediations can get quite expensive, can't they?
Most of the time, they are full-day mediations if we're talking about all of the issues: parenting, distribution of assets, alimony, child support. The goal is to have a signed agreement by the time you walk out of mediation. And so, yeah, it's a lot of issues to address, and it's typically a full day. If not, it spills into a second day, honestly. So it does add up by the time you're paying your lawyer, your spouse is paying his or her lawyer, and the mediator is obviously an additional expense. So it's beneficial for both parties and lawyers to walk into a mediation being prepared, so that a lot of time isn't spent on the mediation clock getting up to speed and getting prepared.
And then to take it a step further, when people throw around trial, because let's be honest, we've all watched Law and Order. We're all like, well, we're going to go onto a trial and do all of that. Then the costs skyrocket, correct?
Yeah, for sure. Because at that point, you're serving tons of discovery requests. You're taking depositions of any potential witness. You are preparing pretrial memos, memorandums of law. It just goes on and on. Just your attorney's attendance, those 3 days, not even including any prep work, is a substantial expense. And that doesn't include court reporter costs, making copies of 1 million exhibits. It adds up quick. But by the time you get to a trial, the time also adds expense. More issues come up. Judges are scheduling, it depends on the division, but some judges are scheduling 4, 6, 8 months out, depending how long of a trial you need. So you can imagine the additional issues that also come up while you're waiting for your trial. So it gets expensive for sure, which is why I think clients need to make sure when they're considering settlement that they're considering the alternative, the cost of trial. How much is it going to take me to get to the end of my case? And is it worth it? So how far apart are we in our financial positions? And does it make sense to pay the lawyers and pay everyone else involved in the process, the financial experts, the parenting experts? Does it make sense? And I don't know that clients truly consider that early enough in the process a lot of the time. And then they almost get so far in that it's too late to do that analysis.
Right. And I think it's important to add, and you've been mentioning this throughout, is how much is your time worth, and the stress of 6 more months, 8 more months. And that bill just continuing to go up and up and up, and really considering, because at that point, like you said, once you're in it, you got to finish. So then what does that look like in terms of just fees and time and all of that?
Unknown.
It
can be,
exactly.
The range is so wide. So, I mean, if your case pens for 2 to 3 years, you're talking about a lot of money. Mm-hmm. But if you can settle your case after you exchange financial disclosures and you're at your first mediation, the cost is substantially less. It doesn't make sense always to settle at the first mediation, especially if you have an unreasonable other side. Mm-hmm. But the hope and the goal is that both parties are coming to mediation in good faith and being reasonable with the goal of resolution. That's not always the case, but that's the goal.
And I think it's worth mentioning for people that are in that preliminary stage, when Nicole mentions a financial affidavit, financial disclosure, it's like 12 or 14 pages. It's everything from your mortgage to how much you pay to get your dog groomed. I mean, it's every single expense that you have, all of your assets, all of your liabilities, fancy way of saying debt, everything is on there. So there is a lot of discovery and disclosure that you have to do in the beginning. And I always tell people, and I'm curious what your thought is on this, because I typically am involved in the process to kind of be an accessory to the quarterback. I call you guys. Divorce lawyer is always your quarterback. And then for that financial piece, a lot of times it's really just talking through the numbers, what it will look like, getting everybody to a place where they can really just say, how do we equitably distribute the assets and move on, right? And more than that, when you do that distribution or that division of assets, giving people peace of mind that like there's hope afterwards, and we're doing it so that way you do have a life that you can afford and enjoy moving forward. And I think giving people that peace can really help them kind of come to an agreement. So I always tell people, if it's under $5,000, don't fight about it unless it's like a family heirloom that you cannot live without. But typically, in what I've seen, by the time they fight about it, they end up paying more in fees and stress and all of that than the thing was even worth.
You're often correct. Absolutely. The problem is if it's a $5,000 issue here, there, and over there, and it's 10 $5,000 issues, then that's when it starts to become more complex and doesn't make sense to let all of these issues go. But if it's one issue in isolation, yeah, you'll spend $5,000 for a full day mediation, no problem.
So really, again, typically if you're in the divorce process, it's because you don't get along super well with the person that you're divorcing. So kind of weighing the pros and cons of how in the mud do I want to get, how much conflict do I want to have, versus keeping it moving so that way you can get to that desired outcome, which is your independence in the end.
For sure. And I think those are conversations that you should have with your lawyer early on. Is your intention of finding every single penny, or do you want to try to keep it a little bit big picture for a more amicable and efficient resolution? Sometimes, again, it's out of your control because you can't make that decision for the other side. But it's a good point to make sure you and your lawyer see eye to eye on that.
And I'm glad that you said that, because I hear that all the time, that everybody thinks there are all these assets that are like hidden everywhere. How do you navigate that conversation with people?
You know, sometimes the concern is well-founded and sometimes it's not. Sometimes the concern stems from what I call shadow people. So that's friends or family members kind of planting those ideas about the possibility, but really there's nothing concrete to really even look into or dig into. When there is a serious concern, though, that is one of the reasons why I might consider suggesting a financial expert, getting a forensic accountant involved, because the forensic accountant can, at the client's direction, assuming that somebody wants to fund this analysis, is to look at all of the accounts, make sure that any payments going out that we have where they're going to, looking at wires in, wires out, where cash is, withdrawals. I mean, there's a lot that can be looked into. It all just costs. But if there's a serious concern about hiding assets or funneling money somewhere, it can pay off to have those analyses done.
I always compare it to, remember that show Deal or No Deal? When they would have the briefcases and you don't know what's behind it. And it's like, well, if it's $500 and you spent $5,000 on experts, it's not worth it. But if it has $200,000, then it's worth it. So I always kind of give that visualization to people, you know, and just terminology that I want to make sure that we cover. So forensic accountants are going to be like your CPAs, where their job is to look for assets that might be hidden, if you will, for lack of a better term. Good example, a lot of times I tell clients, it's more for people that have businesses. If you've got two people that are employed by somebody else, usually, I think a lot of the time, not all the time, but it's less complex than if they've got three businesses or investment properties. I've had clients where their spouse is from another country, things like that. That's a little bit more likely you'd use like a forensic accountant. And then more of what I do, like a CDFA, Certified Divorce Financial Analyst, is more looking at your assets that have been disclosed and trying to figure out a way to divide those where both sides are happy and it's an equitable distribution of those assets. So they're two different experts, and there are a million different people you can hire throughout the process. Another big one I hear a lot is a vocational expert.
So that's generally in cases where alimony or child support's an issue, and there is historically one spouse that believes the other spouse is either unemployed or underemployed. So one example is a stay-at-home mom, hasn't worked in 3, 4, 5, 6, 7 years, and now is requesting alimony or child support. Well, the husband in that situation, again, hypothetical, it could be either way. In that situation, the husband's going to probably ask the wife to submit to a vocational evaluation. So then the vocational expert would assess educational background, professional qualifications, do labor market research, and really come up with a range that expert believes this person could earn if they went out and found a job right now in the same geographical location that they're in. And so then that number is a starting point really for negotiations, but ultimately that's the evidence that the spouse would present at trial as to the other spouse's ability to earn, because there is an obligation to help contribute to your own expenses and for child support purposes. So income is a big factor in both of those analyses.
And I want to talk more about that, but I want to say one other thing in terms of potentially hidden assets. Something free you can do is your tax return is your treasure map. So if you have anything on the tax return, a lot of times that's a really great place to look to just see if there are things you didn't know about. An example would be if somebody did a rollover, if they took money from their 401k and rolled it into an IRA. If that's on the tax return, that can be kind of like your free treasure map step one. Mm-hmm. If you go more complex than that, then you would look at like a forensic accountant. But now I want to circle back to the alimony piece because we hear that term all the time. I typically, if there's a situation where a client can afford to take a lump sum, a lot of times I will always present that as an option, but I've seen it work out really well for clients. So high level, can you talk a little bit about alimony, lump sums, things like that?
Yeah, sure. So there were some big changes in our alimony statute a couple years ago in 2023, where there was the elimination of permanent alimony. And now the legislature has developed caps depending upon the length of the marriage. So whether you are a short-term marriage is different than a long-term marriage, and the length of time that you can receive alimony, the types of alimony that you can qualify for. The legislature has also included a cap of how much alimony you can receive on a monthly basis. So there's now a calculation. It doesn't specifically determine how much alimony should be, but it says it can't exceed X percent based upon the net incomes of both parties. So you first have to figure out what incomes are we using for both petitioner and respondent, and then conduct this calculation. But again, that doesn't tell you the amount of alimony it should be. It just sets forth the maximum amount. That did not exist in our prior statute. But it is very fact specific and depends, every case is different. So durational alimony exists, permanent alimony no longer exists.
In Florida.
In Florida, correct. Anything I say only relates to Florida. I am only barred in Florida. So yes, absolutely 100%. As far as lump sum alimony, I don't find that a lot of payors are interested in paying lump sum alimony.
Oh, interesting.
With lump sum alimony, one thing to consider is somebody that's paying lump sum alimony is going to want a present value discount. So let's say the alimony amount is $5,000 a month and the term was going to be 5 years. The payor is likely not going to pay the lump sum of that total amount. They're going to want a discount to pay less than that if they're front loading it all right now, because then the recipient could take that lump sum, invest it in the market, and start making money off of it. That's something that the payor could have done over time. So you have to consider, is the present value worth it? What's the risks? What if I took monthly alimony and then something happened to the payor? Is there a risk of that? Is there a risk that I'm accepting lump sum, but the payor's income is going to drastically increase? Whereas right now he didn't have enough to pay how much alimony I truly needed and could have received. So then if you receive lump sum, are you waiving the right to get additional alimony in a modification action? So there are a lot of considerations when assessing a lump sum alimony case, but your role is critical. Those are a lot of financial planning questions. So does taking a lump sum right now help you because you need to buy a house and you can't afford the super high interest rates? That's a financial planning question. That's not necessarily a lawyer question. That's what makes sense for me in my situation right now, looking ahead post-divorce. So that is when I do sometimes suggest to my clients, why don't you meet with a financial planner now while the divorce is going on rather than waiting until after, and at least get some advice. Does it make sense for you to stay in the home? Can you afford it if alimony ranges from this amount to this amount? So they're better questions to start getting answers to early on rather than waiting until after the fact and then realizing after I've been distributed this house, I can't actually afford it.
100, and I'm glad that you said that. And a big thing too is if you are receiving alimony, have some kind of a life insurance. To your point, if somebody passes away that's paying you, they don't have to keep paying you, right?
Right. Alimony terminates upon death of either party. So having a life insurance policy to secure support, whether that's alimony or child support, can be life-changing in those situations.
And I always say, and I'm so excited to have you on to kind of just legalize, if you will, the kind of euphemisms that I tell people. I always say your divorce decree is like your Bible or like your blueprint. So whatever is in there, that's really going to be pretty much set in stone unless you spend a lot of money to change it. So just making sure you spell out everything as detailed as you can with as many considerations and hypothetical scenarios to cover yourself as best you can, I think is really important.
Yeah, no, I agree. I think it's absolutely critical. Most marital settlement agreements specifically say that there are no other agreements between the parties other than what's set forth in this agreement. So even if your spouse has promised you something, if it's not in that document, it's not in there. And you've now signed a marital settlement agreement saying that there's not any other agreement otherwise. So it is really important to make sure you have a complete and detailed settlement agreement.
And I want to ask you this so that way everybody hears it, but I know your answer, what it's going to be.
Okay.
What about the people that say, no, we're getting along right now, so we're going to text on the side because then we don't have to pay our lawyers to figure some of this stuff out?
I wish I could say that doesn't happen, but people come to us all the time and say, oh, we've got an agreement, or I talked to my spouse and we agreed on this. 9 times out of 10, those people walked away from that conversation with completely different understandings of what they agreed to. So it often causes us attorneys to spend more time and money on an issue trying to figure out what they talked about, what the outcome is, and then realize there's not an agreement, and we're back to square one. So it's never my advice to start having these discussions offline with your spouse while you have 2 lawyers involved. I mean, that's what you're paying them for, right?
Yep.
And hopefully we can get ahead of issues rather than parties creating more issues by trying to streamline without us.
So it can actually become more expensive if you do the offline stuff.
Yeah. Now, there are obviously exceptions to that. If you want to try to divide up personal property, be my guest. I mean, that's not really a legal analysis of who's taking what couch and who's taking what bed. So that's a good example of one way to maybe try to resolve something with your spouse if you're on fair grounds. But beyond that, it can get tricky.
I'm glad that you had the answer I thought you would have. Good. So I do want to say thank you so much for also presenting at our second Saturday workshop. So for people that are listening that are either in the process or they're contemplating divorce, there's a really great nonprofit called wife.org. So it's Women's Institute for Financial Education, but men, you can go to the workshops as well. And they're called Second Saturday. They've been around for, I think, about 30 years. And there are these workshops that have a lawyer, a financial professional, and then a mental health professional. And they each speak about those different aspects of the divorce process. They're either free or in some places they charge $5 or $10 to attend. Ours is free here in Tampa Bay, so it's Second Saturday, Tampa Bay. And Nicole, you were our presenter at our last Second Saturday, so thank you so much for donating your time. And I was just hoping you could kind of speak to the workshop and kind of its value in the community and what you took away from it.
Yeah, I thought it was a great opportunity for me to give back. I do paid consults, so this was an opportunity for me to really help educate some people that are either considering divorce or maybe in the beginning stages. So while it's big picture legal information, I do think that everyone that attended walked away armed with so much information as it relates to the process and some of the substantive issues. So it was really a great opportunity for me to give back to that group. I thought it was a great, engaging group. Yeah, it was really nice. It was really nice. Thanks for having me.
Well, thanks for coming.
Yeah.
And if you're local, like I said, you can find us at secondsaturdaytampabay.com. We're on Facebook, Instagram. It'll probably show up in the graphics on the bottom of the screen here. And then if you aren't local to Tampa Bay, you can go to secondsaturday.com and they have a map of the United States with all the different workshops. So it's a really great free resource most of the time for you to be able to go. And like I said, if some places charge a fee, it's not expensive. But it's a great way to kind of get access to a lot of this information. And I love hosting them. So thank you for coming to that.
Yeah. And you had some other great speakers too. It was really nice to meet them.
Yeah, they enjoyed meeting you too. It was great. So, okay, I have to ask you about the other parts of the divorce process. So let's talk about after the happy ever after, when everybody's split and you see specifically on the show, we talk about women. What are some of the things you see from your past clients? You mentioned you get follow-up from them and things like that. What do you see in terms of their finances, in terms of their lifestyle? What is life like at the end of the tunnel?
I think at first it's a really big adjustment. So generally, and this obviously doesn't apply in every family, generally the mom or the wife is not the one in charge of the finances. They're generally not the breadwinner. There's always a division of responsibility in marriages. Every family is different, but big picture, that's not been their role. So after a divorce, generally you're expected to start working. On top of that, you're now managing your own household. You're figuring out your finances on top of everything else that you're doing potentially as a mom with little kids or caregiving for a family member. So it's a big adjustment and can be very overwhelming at first. So that's one reason why financial planners can be so helpful, especially as that transition is going on. But generally, once you get past that transition and you start getting into your routines and your new life, that's when I start getting the positive texts and emails and Christmas cards. But not everything is always rosy. I mean, divorce is hard and you're typically connected to your ex-spouse for one reason or another. That might be minor children, payment of alimony,
dogs, cats,
lots of issues. So a lot of times we hear from our past clients for post-judgment issues, whether that's modification or enforcement. And so it's not always just perfect after the divorce.
And that's something I wanted to mention about considering alimony is that I always tell my clients, somebody can be ordered to pay you alimony and you might, and you should end up getting it in the end. But if your spouse is or ex-spouse is not willing to pay it, it can become a lengthy, stressful process. And also you can modify alimony. I wanted to make sure you touched on it before, but I wanted to make sure we let people know there is a process, correct, to modify your alimony?
Yeah, so to modify, you do have to file a supplemental petition for modification. It's not a quick and easy process. Not much is in the legal world. So you go through financial disclosures again. You have to make sure you have a legal basis to modify. Otherwise, your ex-spouse is going to file a motion to dismiss to try to not even let you get financial discovery. So it really depends and is a great piggybacking on the marital settlement agreement. It's a great example of why you need to make sure you have really solid language in your settlement agreement. So spelling out what bases, if any, make your alimony modifiable. You can agree to non-modifiable alimony. Makes sense sometimes, it doesn't make sense sometimes. So really looking to what your settlement agreement says or whether it just refers to the statute. And then you have to figure out, do I have a basis to modify? Because if you received the absolute maximum under the law at the time of your divorce, you probably don't have a basis to modify to get more. But if the payor couldn't pay you the amount that you needed, you may have a basis if now the payor is making more money and there's sufficient income to pay that deficit that they couldn't quite meet at the time of divorce. So there could be a basis, there could not, but there's also a cost associated with pursuing the modification, of course.
I appreciate you saying that because that's true too.
Yeah.
A lot of moving parts.
There is. And that's why you can't rely on ChatGPT or Google for answers.
And that's why you can't do that for finance either, because there's too many moving parts. And I wanted to mention, just as a metaphor, I always say during the divorce, your lawyer is your quarterback. But a lot of times what I've seen with clients is I typically will come into the divorce process a little bit later, just because I'm happy to be on your team, but I don't run your team, right? And a lot of times I've noticed with clients, they're so used to that interaction with their divorce lawyer that when everything ends, it's kind of like, okay, we're done. And they're like, what do you mean we're done? You have to go help other people. And so it becomes a nice relationship where that CDFA role ends, and then I can act as their financial advisor moving forward. And it's always nice to have relationships with the divorce lawyers that we work with, just because if there needs to be some kind of a change, it's great to be able to reach out to you again for that as well.
For sure. In our office, at the end of a case, we actually do kind of an exit interview or closing meeting a little bit after the divorce ends, because it can be very abrupt. You spend so much time together for many months in most situations. And then if you settle your case at mediation, there's not much left to do. And so it can be a very abrupt ending. So we do like to check in, a month or so after. We also like to prepare what we call an executory task letter that identifies all of the action steps in the settlement agreement. Because your agreement might be 30 pages and it's pretty overwhelming as a layperson to try to read all of this legal jargon. Yep. And so then you might have this task letter listing all of these 30 steps you need to take within different time frames. And oftentimes people like you, Taylor, can actually help do that. So help guide, how do we get this bank account divided? How do we get an IRA split or this transfer accomplished? That is not generally something that most lawyers help with, but that is something that you can help with.
And we do a lot of that, especially just making sure that retirement assets transfer if they can without a taxable event. And we could go into more detail on that, but there's a lot to it to make sure everything transfers. So that quarterback role, you basically give us the football at that point, and we kind of help them transition that process and really build out their team moving forward, right? Because typically they need to go to an estate planning attorney, because if they had their ex listed on everything, they probably don't want them on there anymore. And just a bunch of different people to build out. They have to refinance their house, or they're buying a house or selling a house, or all of those different people. That's where I always say that's where that role shifts and we become that quarterback for them. But I'm so grateful to have you guys for the first part of it to get everything wrapped up. And I always try to tell people, like, defer to what your attorney says. Do not try to do it yourself.
Yeah. Well, always defer to your settlement agreement, but then ask your lawyer questions.
Oh, this is pre-settlement agreement.
Oh, okay, okay.
Which actually, I'm glad that you said that, because I wanted to clarify as well. Marital settlement agreement, divorce decree, same terminology.
So a marital settlement agreement is if you can settle your case. That's where you summarize all of the terms, whether that's alimony, child support, equal distribution, what you're doing with cars, how you're dividing personal property, attorney's fees. Everything goes in that master document, and that document typically attaches a parenting plan, child support guidelines, and both parties sign that. It's a contract between the two of them. And the divorce decree that you're referring to is what I generally call a final judgment. They're called final judgments of dissolution of marriage. That's the court order that actually approves your settlement agreement and divorces you. So you're not divorced the day you settle your case in mediation or any other day. It's when the court approves it, determines they have jurisdiction, and signs the final judgment, or the divorce decree is another word for it.
Okay, interesting. So is the marital settlement agreement like an attachment to the divorce decree?
Generally, yeah. You attach the MSA as the abbreviation for it to the final judgment.
Good to know.
Yeah.
Okay, so now I'm going to ask you a little bit more about those bookends I talked about.
Okay.
So the first one that people ask me about all the time is, before you get into the marriage, let's talk about prenups. And I'm just going to say that. Tell me what you want us to know about prenups.
Prenups are becoming increasingly more popular. The amount of calls that we get for prenups, even if you just look at this year, the first 2 months compared to say 3 or 4 years ago, they're becoming increasingly popular. I think a lot of that is because more women are entering the workforce. A lot of prenups are not as one-sided anymore. So we're getting a lot more calls where both parties are interested in protecting what they have coming into the marriage or what they intend to have during the marriage. So prenups are completely customizable, but they can be awful for you, especially if you're just downloading a document online and you have no idea what you're signing. So they can be extraordinarily helpful, but they can be extraordinarily damaging if you don't have a good one.
Why?
Because that's what's going to control the terms of your divorce if you get divorced in 5, 10, 15, 20 years. And so if you've signed something saying upon divorce, your spouse is going to get X, Y, and Z, and you didn't realize it because you just downloaded a form online, your prenup is what controls, unless you try to set it aside and the court finds that it's not enforceable. But entering into a bad deal is not in and of itself, or sometimes even ever, a legal basis to set aside a prenup. So they can be really helpful if your attorneys actually help you draft it and follow all of the processes to make them as enforceable as possible. But just downloading one online is not generally helpful.
You were speaking my language. You said a bad deal. I love that. So really, you could just make a bad deal for yourself.
You could make it worse for yourself.
Wow, interesting. Because what I hear a lot is people are always concerned that it won't be enforceable. How realistic is that?
I think with time, courts right now are upholding contracts, because that's what a prenup is. It's a contract between two parties.
Just like getting married, right?
Just like any other contract.
Yeah.
So there are things that certain lawyers do to try to make them as enforceable as possible. So a couple quick examples. I like to have signing meetings where there's a court reporter present. I like to ask questions before the prenup is signed to make sure that people are there freely and voluntarily, make sure that they don't have any other questions about their soon-to-be spouse's assets or income, that they've done all analyses and valuations that they wish, because one big component of it is financial disclosure. So if you have somebody testifying under oath in the presence of a court reporter and you later get a transcript that you have all the information you need, you don't want anything else, you're ready to sign, nobody's forcing you to be there, so you can't claim you are under duress or someone coerced you to 10 years down the line. So there are things that us lawyers can do to try to make them as enforceable as possible. We can never guarantee things. So if a lawyer is guaranteeing you that it will be an enforceable prenup, that's not accurate and possible, but there are things that we can do to make them as enforceable and protective as possible.
Nicole, you're hired. When I get married, you're hired. That sounds good. It's on the record.
Yeah.
Very cool. Okay, so I've heard this from people. They say that if you make a prenup after your invitations go out, it's considered duress, and that is that true? Or is that ChatGPT nonsense?
That is probably ChatGPT nonsense. Now, I think that there's some truth that you could take from it. It is beneficial to not sign a prenup the day before your wedding when you have 200 people that just flew into town for this $100,000 wedding. Mm-hmm. Because if you think about that from a coercion, I felt like I was under duress standpoint, it's much better to sign a prenup a month in advance of a wedding because it's much easier to cancel or stop at that point. So signing it the day before, not recommended, but I am not aware of any type of rule or law that says anything about sending wedding invitations out in the timing with a prenup.
You heard it here, folks. Very cool. Okay, so then let me ask you this. I am of the opinion that women who quit their jobs, is that a good point to get some kind of a postnup? Or how do you feel about postnups?
I think postnups should be used sparingly.
Ooh, okay, why?
I don't think that it always makes sense. I don't know that quitting your job is a reason for a postnup. So postnups can be as limited in nature or as broad as both parties want them to be. But again, it's a voluntary agreement. You're not going to be able to force your spouse to sign a postnup. And a postnup, just to be clear, is pretty much a prenuptial agreement, but it's an agreement signed after you're already married. So this agreement could dictate what happens in the event of divorce or in the event of death if that happens and you're still married. I don't think postnups make sense a lot of times that people are calling us for postnups, it's really just a precursor to divorce. So I think they're just kind of afraid to pull the plug on divorce. And so they want a postnup. But then we often see people back very shortly thereafter saying, okay, we're ready for a divorce.
So do you have any advice for women like us, right? Where if you are a professional, you're making substantial money, and then you make a marital decision for you to either stay at home full time or take a part-time job or something like that. I have clients that will come in my office that chose to do that 18 years ago. And then typically it's when the kids go off to college, all of a sudden they get told, we're getting divorced and this is all my money that you're taking from me. I hear that with almost every woman that comes into my office. What advice would you have for women? It's obviously different when you're 18 years down the road, but for the women that are contemplating making that choice for their family, are there any kind of protections that you would give them or advice that you would give them?
I don't know that it's necessarily advice or protection, but I think it's helpful to know that even if you're not the working spouse during the marriage, assuming there's no prenup in place, if one spouse is bringing in all of the money and generating the assets from that money, generally speaking, it's all marital if it's during the marriage. So even if it's titled in an individual bank account, it's generally marital income and a marital asset. And even if you weren't the one generating it, you're still entitled to half through equal distribution unless there's a basis for unequal distribution. So I don't know that that necessarily helps from an advice or protection standpoint, but maybe gives some peace of mind that you can still walk away with a relatively equal net estate, even if you weren't the one that brought in the income during the marriage.
So I think that that's really important because what I'm hearing from you is it's more so trying to drown out some of that inflammatory language that your spouse might be saying to you, and listening to episodes like this or different people, experts that talk about, it's one thing for your partner to say, well, you're not going to get anything. It's all mine, whatever. But there's no legal basis for them to say something like that usually.
Right. That's noise.
That's noise. Yes.
That's noise. Ask a lawyer who practices family law and get a better understanding of what marital income is, marital assets, and how equal distribution would apply in your situation.
I love that. And I wanted to circle back to on the prenup of it all is that if you're worried about protecting your assets, pay an expert to help you. Don't protect your assets and then cheap out and print something for free off of the internet. Because if the whole point is to protect your money, give your money the best chance of being protected as possible and hire somebody like you to help.
100%. And even though it requires dishing out money on the front end for the prenup draft and the signing meeting and everything involved with that, the goal is that it's ultimately going to save you money if you ever get divorced. Hopefully the prenup is very easily interpreted and applied, and there's no disputes, there's no litigation about enforceability, and hopefully then your divorce is cheaper. So it's never guaranteed, but that's the goal, right? So you're front loading a little bit, but hopefully it's saving you in the end.
Right. And if you didn't have the assets, typically there would be no point in doing it anyway. So it's almost implied that you have something worth protecting or you wouldn't be doing it.
Right. And you have the desire to protect it, because some people will walk into a marriage knowingly having substantial assets or substantial income, and they're completely fine with not protecting it in terms of a prenup. But if that is something you desire, then you should follow through with it in the right way.
And a small question off of that, what about money that you got as a gift or you inherited? Do you have to have a prenup to protect that or no?
A little complex. Generally, inheritance is considered non-marital, but you have to maintain it that way. So if you receive inheritance, but then you use a couple $100,000 to improve a jointly titled marital home, well, you've kind of now made that a marital asset. But if you receive, let's say, $500,000 of inheritance and you create a new bank account, you put just the inheritance in the account and you maintain it that way, well, then it should be pretty solidly a non-marital asset. So it's not as simple as just saying, I received this money in inheritance. It's really, well, what did you do with it after that? How did you maintain it? How did you title it? Did you add any other money to it? So again, a very fact-specific analysis, but you can maintain inheritance as a non-marital asset, even if it's received during the marriage. It's just whether you did it the right way.
And again, if you're worried about protecting it, then it's worth consulting an expert to make sure that you're going to be able to do that.
Yeah, 100%.
And I can't think of a better one. So thank you so much for coming on the show today.
Thanks for having me.
Where can everybody find you?
Well, we have offices in Tampa and St. Pete, so no need to drive over the bridge, depending where you live.
That's a big thing around here. People don't drive over the bridge.
I swear, the bridge is a stop for a lot of people. So
it is not the Golden Gate Bridge. It is a very easy bridge, and people just refuse to drive over it.
For sure. So we have offices on both sides. So anything family law related, divorce, paternity, prenups, postnups, that's what we do day in and day out.
Well, thank you so much for coming on the show today.
Yeah, of course. It was fun.
I'm glad. And thank you all for listening. And remember, until next time, your wealth suits you better when it's tailored. High five. Nice.